I'd just like to conclude by expressing the hope that you really enjoy this afternoon's event. Thank you, and I'll now hand over to my colleague, the Principal Investigator of the JCOERE Project, Professor Irene Lynch Fannon. Thank you.
Thank you, Professor Poustie, and welcome to this afternoon's event, everyone, on corporate rescue and support for businesses post-COVID. The JCOERE project, which, as Mark has described, is based at UCC and involves European partners, some of whom are joining us from the University of Florence, the University of Timișoara in Bucharest, and INSOL Europe. It's funded by the EU Commission DG Justice, and as Mark has mentioned, I am the PI and coordinator of the project. So the moderators for this afternoon's event include myself and then Drs. Jennifer Gant and Dr. Eva Finnerty, who are all members of the JCOERE Research Project at UCC School of Law. So the two overarching themes of this afternoon are, first, a consideration of Irish examinerships and schemes of arrangement as exemplary frameworks for corporate rescue, an important matter both in light of the implementation of the Preventive Restructuring Directive 2019 in all EU states, and for Ireland as we hope a preferred location for legal services post-Brexit. The second theme relates to the continued development of our rescue frameworks to support small and medium-sized enterprises, a matter which has recently been the focus of the Company Law Review Group Subcommittee on Insolvency, which I chair. We have three sessions, beginning with contributions on recent cases in examinerships from Judge Michael Quinn and Judge David Barniville, both High Court judges sitting in the commercial division of the court. This is followed by contributions from two eminent European scholars, Professors Jerry McCormack from the University of Leeds, speaking on the UK Corporate Governance and Insolvency Act 2020, and Professor Reinhard Riesendorp from the University of Leiden and De Brouw Blackstone, speaking on the new Dutch WOA legislation. And finally, we will hear from Neil MacDonald, President of ISME, and the Irish Small and Medium Enterprise Association, and Barry Lyons, solicitor who is legal advisor to ISME. Both Neil and Barry sat on the Company Law Review Group subcommittee with me during the summer while we worked on new initiatives in this area. So to you, the attendees, before I begin this first session, please note that we have over 200 participants, so there will be a moderated question and answer session, where you can enter your questions in typed form. Those will not be visible to the audience generally, but each moderator of each session will put a selection of questions to the relevant panel. And this question and answer session will follow each individual session. So, if I may, without further ado, could I welcome all of you and begin our first session, welcoming Judges Michael Quinn and David Barniville, and asking Judge Quinn to begin with recent cases on examinerships. Thank you.
Good afternoon, everybody. You can all hear me? Yeah. Thank you, and thank you for the invitation to participate in this afternoon's session. I'm going to focus on one aspect of corporate restructuring in Ireland under our Companies Acts, and there are numerous tools available in Ireland as in other places for restructuring of businesses and companies. And I know later in the afternoon you're going to hear about potentially new tools and tools that might be more readily accessible by small and medium enterprises. But the two that we're focusing on in the first part of the afternoon are the devices by which, under our Companies Act 2014, schemes of arrangement can be used to restructure the affairs of a company. And Judge Barniville will be talking to you in a few minutes about Part 9 of the Companies Act, which is the framework for schemes of arrangement, not unlike the schemes that are available in England and which have been available since our Companies Act 1963. And I'm going to talk now about part 10, which is the concept of examinership. And this is a process which was first introduced in Ireland in 1990 under the Companies Amendment Act 1990. And the essence of this is that the court appoints an examiner, an independent officer appointed by the court, whose function is to formulate proposals for a compromise or a scheme of arrangement, which he then submits to statutory meetings of members and creditors, and ultimately submits his proposals to the High Court for confirmation. The company enjoys an automatic stay during the period of the examinership process, but essentially it is also a debtor in possession concept. So the examiner focuses on the restructuring, focuses on the plan for the scheme of arrangement, and does not assume any executive powers. In exceptional cases, he can apply to court to take certain powers which would otherwise be exercised by directors, but it's typically a debtor in possession process, with the examiner focusing on the rescue plan and reporting to the court. One of the big features of Irish examinership, which I think might be of interest in the context of comparisons with other jurisdictions, and also in the light of the EU directive on preventive restructuring, is that entry into the process is not automatic. The company or the debtor company seeking to avail of the process will file a petition for examinership or for the appointment of an examiner. That filing confers automatic court protection or the stay for the duration of the examinership, but the court will fix a hearing to confirm the appointment of the examiner, typically within a couple of weeks, anywhere between 1 and 3 weeks from the filing date. And a full hearing before a judge in the High Court will be held for the purpose of determining whether this is an appropriate case to enter the examinership process. And that's important because the court protection or the automatic stay, and ultimately the effects of the scheme of arrangement, which include such things as cross-class cram-down, are very serious and significant infringements on rights of third parties. And so balance is required. And the scheme of our legislation follows a policy that if that privilege is to be afforded a company, that those benefits, then it must be shown at an early stage that the company is a suitable candidate for the process. And the tests, the first aspect of the test for entry is to establish that the company is insolvent, either on the balance sheet basis or on a cash flow test basis. So if the company can be described as insolvent under either of those tests, it will be eligible to enter into the process. Importantly, the section 509, which introduced the process, introduced the concept that insolvency would include a company unable to pay its debts or likely to become or to be unable to pay its debts. And I'll be coming back to that in a moment, because that widens the availability of the process to companies which may be on the cusp of or approaching formal insolvency. So once insolvency is established, the court then has a discretion. But the discretion is the important word here. It is not automatic. The first element of the discretion is that the Act expressly provides that the court may only appoint an examiner if it is satisfied that there is a reasonable prospect of the survival of the company and all or part of its undertaking as a going concern. So this cannot simply be a device to restructure a balance sheet or cram down creditors' claims. There must be a viable entity, a viable business. This is the policy of the legislation, which can be rescued by the use of this process. And that's a rigorous test. The Act requires that the petition be supported by evidence from an independent expert, who is usually an accountant, frequently an insolvency practitioner, who will present to the court not only basic financial information and data about the company, but get, as it were, under the bonnet, so that the court has in front of it detailed evidence on which to assess the question of the reasonable prospect of survival. So the viability test is a really important piece of our legislation, and it's probably just, again, in the comparative context, worth noting that the directive discusses the restructuring directive from the EU discusses viability at 2 stages. One is the possibility of introducing a viability test at the initial filing, so that member states may introduce a viability test. Well, we've had the viability test since the commencement of this regime in 1990. It was only in 1999 that the requirement for the independent experts report was introduced, but it's always been at the heart of the process. So there's been numerous cases testing viability, and viability includes not only financial viability, but just looking at market information, and influential factors include the saving of jobs and employment, and I'll come back to that separately. Before I leave the question of viability, in practice, in our cases, at the end stage when the examiner is reporting to court to confirm a scheme of arrangement, his report will identify and describe how this scheme of arrangement, if confirmed, will facilitate the medium to long-term survival of the company. So again, the court will be reluctant to confirm a plan if all it does is fixes a balance sheet but doesn't have some visibility. There's no rule as to how far into the future, but it needs to have evidence that this is going to facilitate a business surviving in the medium to longer term. And again, the directive talks about the possibility of introducing viability tests even at the confirmation stage, and we've always regarded that as an important feature of the regime here. Finally, though, in relation to the entry exercise, I would just say that the whole question of the discretion of the court is very wide, and discretion means looking at all of the facts of the case. Not only is the company insolvent or likely to be unable to pay its debts, the question of viability and reasonable prospect of survival is central to this, but is the process being used for a proper purpose? And there's a very significant recent judgment by my colleague Judge MacDonald in a case called New Look Retailers, which concerned a chain of ladies' fashion stores, UK based, and it had something in the order of 27 stores in Ireland. And I won't go through the detail of that case too much, other than to say that this was a case in which, in fact, the company was identified as solvent on a balance sheet basis. There was some debate as to whether it was going to be unable to pay its debts in the near to medium term. The judge found that it was sufficiently close, even if it was a few months before it would run out of cash, it was sufficiently close as to be unlikely to be able to pay its debts. But the controversy arose as to whether this was a proper use of the process. And in that case, the filing was made in circumstances where it was intended that the examinership would be used to repudiate leases of stores throughout the group. And in the early days of examinership, this was really a minor feature of examinership. It then became center stage for a string of restructuring cases through the noughties principally. But it was clearly established by the Supreme Court in a case called the Linen Supply Company that it was a valid use of examinership to avail of the process with a view to repudiating leases and restructuring leases if necessary. But in this case, Judge MacDonald was not persuaded that the company had exhausted all of the processes and negotiations that could otherwise have been exhausted before it should come to court to avail of examinership. And the counterparts, the landlords on these leases, objected to the filing, and he agreed with those objections and determined that this was not an appropriate case for a filing at this time. And it's just an illustration, I think, of the very wide discretion that's conferred on the court to take account of all aspects of the filing and so on. I mentioned earlier that I know we only have, I think, something like 10 minutes, but I suppose the ones I'll touch on are the question of cross-class cram-down and time limits, which are central features of this. The Act says that when the examiner has formulated his proposals, he can bring them for confirmation by the court, provided at least one class of creditors has approved the proposals, just one class. So if he has passed over that threshold of having just one class approve the proposals, and that's a simple majority in value in terms of the creditors, he can then move forward to a confirmation hearing. And the Act is quite clear about the tests at that second stage. And as some jurisdictions will be familiar with the concept of fairness hearings and valuation hearings and so on, the tests are that the scheme is fair and equitable and not unfairly prejudicial to the interests of a party which is objected. And typically the examination is as against what would be the outcome on a winding up. And that's what brings you into valuation type disputes. But the concept of cross-class cram-down has been with us and well tested. There are numerous cases in the Irish system, including valuation related cases and treatment of secured lenders and so on over a period of time. And we're well familiar with this, and it's well enshrined. And it's interesting to see that the directive is proposing that this will be available more widely throughout the EU. But there's plenty of experience of that here since we introduced it. I can go back to any of these in more detail if you like, but I thought I'd just identify the question of time limits, which is important to focus on for a moment, because our process is very strict in its time limits. From the date of the filing for examinership, the process can last only for initially a period of 70 days. The first report of the examiner comes within 35 days, but 70 days is the ordinary outside time limit. Many good cases, even complex cases, have been concluded in less than this. The 70 can be extended only to 100 days. Thereafter, the company can remain in the process while the court is considering the scheme. Emergency legislation introduced this year in August, and which expires at the end of December but may well be renewed, permits a further 50 days, which is significant. But these time limits are we consider very important because they're consistent with the urgency of the process. They're also consistent with the balance against the infringement on the rights of other parties to enforce their remedies, secured lenders' rights to appoint receivers, and so on. And again, in the comparative context, the directive introduces or proposes, I think, a 4-month duration for the protection in the first instance. And it then also talks about extensions, potentially up to 12 months. And the regime that they seem to have in mind for member states is that the extension will be available, firstly, if adequate progress, real progress is being made in the restructuring. And secondly, if it can be shown that there's no unfair prejudice to affected parties by the extension. But the period that's identified in the directive as an option for member states, and I think this is important, it seems to be an option to go up to a 12-month period. Now, again, our experience, even though there's been a number of amendments to our legislation in the 30 years, we've stuck with the core time limit that I've mentioned, the 70 days to 100 days, because we found that to be acceptable. We found it to be efficient. It heightens the urgency of the process. And even in very complex restructurings, one of the biggest examinerships we've had in Ireland, which was EIRCOM, which was a huge case with international implications for note holders and institutions, was done in a much shorter time frame, largely because in those quite sophisticated cases, much of the plan has been negotiated with many of the significant players before the filing is made. So the fact that we've got such a short timetable, we think is valuable. We're waiting to know what's going to be recommended by your company law review group in relation to how we implement the directive. But I think the experience here of observing those time frames for balance and other reasons has been, I think, a successful feature of the examinership. And I think it's a little unique. So it remains to be seen whether other countries follow and so on. How am I doing on the 10 minutes? Yeah. I think that there's probably a lot more that can be said about examinership, but in the time, and I'm happy to take any questions, but there are just a few big features of the examinership, which I think are I hope, of interest when you're looking at comparatives.
Thank you very much, Judge Quinn, and we will take questions if you want as attendees to put questions into the Q&A. And it is, I acknowledge, a very tall order to describe examinerships in 10 minutes. But also just to note that the implementation of the directive is not actually being, we considered it in the Company Law Review Group as just we were consulted. It's in the department. I think there are members of the department who are listening in, so we need to clarify that. So thank you very much. And then I'm just going to go over to Judge David Barniville, and David is going to talk about schemes of arrangement which have had a bit of a renaissance in Irish law recently, even though they have been very popular in England and Wales following the Great Recession. It's similar legislation as Judge Barniville will describe to you.
Thanks very much, Irene, and thank you to you and your colleagues in the JCOERE project for the invitation to speak this afternoon. I'm going to discuss schemes of arrangement, and in particular how they're dealt with by the commercial court in Ireland. And to do so, I'd like to first of all say something about the commercial court. I'll then talk about schemes, and then obviously later on we can deal with any questions. So firstly, the commercial court, well, it's a division or panel of the High Court. I currently am the president of that division. We have 4 judges assigned to it, including Mr. Justice Quinn and Mr. Justice MacDonald, who you heard Judge Quinn just talk about. And they're 2 people who came from practice with an enormous amount of experience in the area of insolvency, and they brought that experience to the commercial court. Commercial cases, the cases that we deal with in the commercial court, include applications under the Companies Act, where the value of the transaction in question, or where the value of the case is more than €1 million. And there's a particular procedure to get into our commercial court. We've noticed 2 things worth mentioning in terms of the business of the commercial court over the last couple of years. The first is the increasing internationalization of the work coming into that court. And the second is the increasing number of applications to sanction schemes of arrangement, many of those involving significant international or cross-border issues. The business of the commercial court has been, I think, less affected by the COVID pandemic than many of the other courts in our system. From a very early stage after the first lockdown back in March of this year, a lot of the business of the commercial court moved online. Most of our hearings since April, May of this year have been dealt with remotely or virtually. And that's really meant that a lot of our business, including our applications under the Companies Act, applications in relation to schemes of arrangement and so on, have been pretty much unaffected by the pandemic. And other areas of our business have been affected, such as complex witness trials and so on. As the judge in charge of the commercial list, I'm responsible for the cases which come into the list. So I see those cases as part of a filtering device which takes place at the outset. All of the cases, including applications for sanction of a scheme of arrangement, initially come before me, and I give directions and case manage those cases. And for the most part, in the last year or so, I've heard the cases themselves which seek sanction for a scheme of arrangement. And as I say, we've noticed a big increase in the number of those cases over the past 18 months or so. And a number of the attendees of this seminar this afternoon will have been practitioners involved in those schemes of arrangement cases. So briefly, what is a scheme of arrangement? Well, it's a compromise or arrangement between a company and its creditors or classes of creditors, or between a company and its members or classes of members, which is enforced and made binding by the court, provided certain statutory provisions and the elements of a test set out in case law are satisfied. Schemes of arrangement can be used in a large range of different situations. And this, I think, demonstrates one of the main advantages or features of the scheme of arrangement procedure under our Companies Act 2014, and that's the flexibility of the procedure and the range of areas to which it can apply. So schemes can be used between insolvent companies and its creditors, not desperately unlike an examinership process, but some differences. For example, there's no automatic stay of enforcement proceedings against the company, although you can seek such a stay. Schemes can be between a solvent company and its creditors. They can be between a solvent company and its members. And they can be used to effect a takeover or acquisition, or they can be used to achieve or give effect to numerous other forms of corporate restructuring. Recent examples, I think, of judgments we've delivered in the commercial court in the area of schemes of arrangement show the breadth of areas which they cover. I give 3 brief examples. The first is the case of Ballantyne in June 2019, and that involved an Irish reinsurance company which did much of its business in the United States. It issued a series of loan notes governed by New York law. It got into financial difficulties, and it sought to effect a scheme of arrangement with its creditors, including those note holders, one of whom opposed or objected to the scheme. Ultimately, that objection was unsuccessful and the scheme was confirmed. The second example, and there are a number of judgments exemplifying this type of a scheme, where investment fund companies wish to change their existing share settlement structure to a new structure called the International Centralized Securities Depository Model, the ICSID model, through Euroclear and Clearstream banks. And that's particularly important in the context of Brexit. And they seek to do so by means of a scheme of arrangement between the company and its shareholders, which involve the transfer of the legal interests in the scheme shares to nominees and so on. They're quite complex, but there have now been, I think, well, several of those, and there are about 4 or 5 judgments of approving or sanctioning schemes of arrangement of that type. And the third is a very recent example, and it's a scheme of arrangement involving one of the largest commercial aircraft leasing companies in the world, which has its headquarters in Ireland. That's Nordic Aviation. That was an aircraft leasing company that got into financial difficulty and is due to COVID issues and so on. And it sought to put in place a scheme with its lenders of really quite enormous complexity. And it involved the court having to look at a range of very difficult issues, including jurisdictional issues, the enforcement of the order that might be made in other jurisdictions and so on. There were 50 other countries involved and almost 500 aircraft, and from recollection, about 75 different lenders involved. And the judgment in that case involved a consideration of issues such as the Cape Town Convention and so on. And I recall having to look at, I think, at legal opinions from about 20 or 30 different lawyers from jurisdictions around the world. And that case, I think, shows that schemes of arrangement do not fall within the recast insolvency regulation, but do fall to be addressed under the Brussels recast regulation on a jurisdiction. So a whole range of different areas can be covered. The procedure is one I won't go into in any detail, but involves a scheme meeting or scheme meetings being convened by the court or now by the directors. There has to be a statutory majority of 75% in value of those voting in support of the scheme in order for it to be enforced under this provision. And then an application has to be made to the court to sanction that scheme. And the scheme may or may not be opposed in a particular case. We've shown, I think, in the commercial court here that we're able to deal with those cases very quickly and very efficiently, even in the most complex schemes. And some of them are extremely complex. The Ballantyne case I mentioned there, I think, was started, done and dusted with an immediate judgment in 5 to 6 weeks. I think it first came before the court at the end of April 2019. Scheme meetings were convened, they were held, it got back to the court. There was an opposition to the scheme that was fully contested and heard on, I think, the 5th of June, and judgment was then delivered on the 6th of June, dealing with issues of New York law and so on. And it was enforced then in the New York courts the following week under Chapter 15 of the US Bankruptcy Code. I think Nordic Aviation, a similar sort of time period involved, about 5 to 6 weeks from start to the delivery of judgment in the case. I think those cases show, I think, the advantages of our commercial court. It's relevant to a point that Irene made in terms of Ireland being an attractive jurisdiction for this type of business to be done. And I think really there are perhaps 3 reasons for that, and I'll conclude on this. The first is that there are now very experienced and specialized practitioners who deal with these cases, and they've seemed to have been very successful in getting some of these very complex and no doubt very valuable cases to Ireland and to the Irish courts. I think the second is our Act, and the way we've used it has shown a great deal of flexibility in dealing with these applications, which can be dealt with on a very expedited basis. And thirdly, I think our courts have also developed an increasing degree of familiarity with these kind of schemes. Our commercial court judges have got some training in relation to complex financial products and derivatives and so on. And the more we do of these cases, I think the more familiar we are with them, and the better I think we'll ultimately be at dealing with them. So that's really all I wanted to say, Irene, subject to questions at the end. Thanks very much.
Great. Okay. Well, thank you both very much. We do actually have some questions coming in. And actually, the first question is relevant to both processes, and you've raised it yourself, Judge Barniville, and it's also relevant actually to rescue processes generally. And the question was the extent of specific training that you as a court get or judges get in relation to evaluating both financial instruments and the economic valuations of the potential for rescue. David, you've just alluded to that in your last remark, and I think that would be of interest to our broader audience, because this is one of the concerns that has been raised by European commentators and policymakers as to the function of the court in a rescue type process. And it's also relevant, of course, to our extension of the process to small and medium enterprises as well.
I was going to offer the floor first to Judge Quinn, but he seems to be reticent.
He seems to have taken it.
Coming forward. Well, you know, as people know, it's an unusual thing for judges up to now to have really been given any form of training in anything. You're traditionally simply thrown into the job, and you'd bring with you the experiences that you have developed in practice. And that's why I mentioned at the outset that we're fortunate in our commercial court to have judges like Judge Quinn and Judge MacDonald, who have an immense amount of experience in this area, and they've brought all of that experience to the court. I haven't had and didn't have as much experience in the area, so it's been a fairly steep learning curve for me. But I did mention that in the whole area of complex financial products, we have been given some training, and we've been given access to materials from other jurisdictions where similar training has been done. And I think that's only the start of the sort of training we're going to require as these things get more complex, and as we get more of that type of work into this jurisdiction. But it's certainly a new departure. I think it's a very welcome departure that judges would get training in different areas, and it's really probably not acceptable in this day and age that you're relying on experience that you developed yourself in practice, no matter how impressive that experience is in the case of someone like Judge Quinn.
Judge Quinn, would you like to come in?
Only to say, I mean, the scope for dedicating time to the very particular training has been somewhat limited, but you shouldn't lose sight, I suppose, of the fact that expert evidence is always a key, particularly in the contested cases. So if there's an adversarial aspect to this, so there's challenges on the valuation issues and so on, the court will still be reliant somewhat on expert evidence, because you know, the judges themselves won't necessarily have lived with these products even in practice beforehand. So expert evidence is a feature of these hearings, particularly the contested fairness hearings where valuation and so on becomes an issue.
And just to follow that up, in terms of expert evidence, Judge Barniville did also refer to the experience of practitioners. And is it the practitioners themselves, both insolvency practitioners and lawyers, who bring that expertise to the court, or will there be additional expert valuations? Again, this is for our broader European audience in terms of how that actually works in practice.
Well, I think Judge Barniville was mentioning the expertise. There's the two elements of the expertise. The practitioners we are seeing frequent the court, as it were, on applications of this kind, happily have been, you know, experienced practitioners who know how to present these applications, and even the uncontested ones, they will know if there are issues that need to be drawn to the attention of the court that are potentially difficult and so on. But the expert evidence would be expert witness evidence. It would be the witness evidence of a valuer or an expert in these products. So the combination of the advocates and expert in the form of reports, and potentially being examined or cross-examined on their evidence.
Okay.
Irene, could I just come in and
Yes.
talk to that? And the two of the examples I gave, the case of Ballantyne and the case of Nordic Aviation, there was obviously an enormous amount of legal input, and there were law firms from all of those, several different jurisdictions, United States, the United Kingdom, a lot of European jurisdictions, the Far East and so on. But there was an enormous amount of financial expertise went into the preparation of those particular cases, and you could see all over the place that the companies that were seeking the sanction of the scheme had got an enormous amount of a very high profile, I think, financial advice. There were a lot of financial experts involved, accountancy, banking, and so on. So these things, when they're done well, are pretty enormous undertakings. They range from that size to obviously much smaller operations where they're still going to need financial advice and expertise, but obviously they won't in all cases be of that kind of level of involvement.
Okay, and that brings me actually to a second question that's come in, and that actually relates to a matter we'll be returning to at this third part of this session this afternoon. And the question concerns the costs of the process, and the question relates to the costs arising even on entry, and whether this makes this process difficult for medium and small enterprises because of the costs associated even with what we call the threshold question, the viability question. Would you have any views on that?
Well, I suppose maybe on the entry, because I was talking about the proving viability and the entry test, it is definitely an issue, because the examinership, there are certainly cases which are suitable for restructuring by this process where it would be disproportionate. In other words, the cost, you're talking about a fully contested hearing, even to enter the process, and the retention of an independent expert, frequently an insolvency practitioner. These are further teams, and without putting figures on it, part of the evaluation day one will be, is this a process that is worth the candle, or is it disproportionately expensive? And I think that, as I said, it is one of the big differences between our entry stage, which is that test being applied, whereas in certain other jurisdictions, and I think apart from the reference to viability in Article 4, I think, of the directive, I think it is envisaged that these systems should be readily accessible to businesses. That's why I'm looking forward to hearing what's said later about SMEs, because it's gone. Now, you can file an examinership, can be filed in the circuit court. And I think the intention of that was only introduced in relatively recent years. The intention there was that there would be less costs, certainly less legal costs, by filing in the local circuit courts. But when that was introduced, the requirement, the procedure, the requirement for expert evidence at the entry stage, the viability test, was not made any simpler. So I think there's been mixed success as far as that's concerned. Bringing it to local courts hasn't necessarily made that more accessible. So I know there are moves to try and introduce something which would have perhaps a more light touch as far as court is concerned, in terms of court intervention only where absolutely necessary, because there's no doubt that the costs can be a deterrent, should we say.
Okay, thank you. And I think we have just one last question. And one of the reasons I'm going to ask this is that it's coming all the way from Canada, from Matthew Chippen, who was a former student here, who's now a postgraduate student and now has gone back to Canada. And the question is about the Irish Commercial Court, that you might be finding yourselves getting busier with these kinds of actions post Brexit. And the question is, how are you set up for that?
That's an excellent question. So far, I think we're set up reasonably well. But I can see that we're going to need in the commercial court another judge, or perhaps two other judges over the course of the next year or two. I think a business case has been made for the appointment of more High Court judges, and I heard the Chief Justice recently speaking on that. As things stand, there are 4 of us dealing with cases in the commercial list, and we are able to manage the cases as they are with that level of personnel. But if there were to be an avalanche of cases, including cases involving schemes and so on, coming into the commercial list, and I think we might be overwhelmed. I don't expect that there will be an avalanche of such cases. I expect that there will be some more cases, but I think we will be able to accommodate those cases. And I think it's also the case that if government is looking at the manning of courts, they may take the view that the High Court merits an additional judge or a couple of judges, and it may well be as part of the project for Ireland for Law, which is to get more work for Ireland and for businesses in Ireland as a result of Brexit, that it might be seen as a reasonable investment to make sure we're fully equipped to deal with any additional work that can come in.
Okay, well, look, thank you very much. We do have another question actually about a suggestion for reducing costs, but I'm going to reserve that for the third session because it actually is relevant, I think, to what Barry might be saying in relation to that. So thank you both very much, Judge Quinn and Judge Barniville. I'm going to hand the audience over to Dr. Jennifer Gant, who will be moderating the next session. So over to you, Jen, and I will mute myself now.
Thank you, Irene. And thank you all for tuning in, and welcome to our second panel on new rescue processes in the UK and the Netherlands. So many of you participating in this webinar will no doubt be aware of the shift in EU insolvency policy from corporate liquidation to focus on rescuing viable businesses in the last couple of decades. This has found legislative voice in the Preventive Restructuring Directive, which provides so-called harmonizing framework for preventive restructuring procedures to be implemented throughout the EU by July next year. This directive was also a very key part of the research we've done on the JCOERE project. Now, we have two speakers from two different European jurisdictions for this next panel session. And these two jurisdictions are in some senses ahead of the wave in introducing new preventive restructuring procedures. We have the Dutch WOA legislation, which is in part implementing the Preventive Restructuring Directive, and also offers some interesting perspectives in terms of how the procedures will be treated in cross-border insolvency cases under the EU insolvency regulation recast. The UK has also introduced a new procedure that includes many of the key provisions of the Preventive Restructuring Directive, although of course due to Brexit, which we can't not mention, there is not any requirement to introduce the procedures that implement that directive. Both procedures are innovative, robust, and they also raise questions about enforcement and recognition at an EU level. So first, we'd like to welcome Professor Gerard McCormick of the University of Leeds, and also the INSOL International Scholar, who will discuss the new restructuring procedure available in the UK. Professor McCormick will be followed by Professor Reinout Riesendorp of the University of Leiden and De Brouw Blackstone in the Netherlands, who will then take us through the new WOA legislation. This will be followed by an open forum for questions from the audience, which you can do by entering your question in the Q&A box. Professor McCormick, please feel free to unmute yourself now and take the floor.
Okay, thank you very much indeed, Jennifer. It's a great pleasure to be here, virtually at least, in Cork or Dublin in Ireland today. So it's a great pleasure. It's my native land. And well, I do remember Judge Michael Quinn in his UCD days. I think El Presidente, we could call him that. Okay, well, it's a Friday afternoon, so time for maybe some jokes. I don't know. Maybe it's not the time for Boris jokes about Boris Johnson. Well, in 2020, the legislation came into force on the 26th of June. We had this new CIGA, Corporate Insolvency and Governance Act in the UK. And there are essentially three main permanent features of the Act. Well, one is what might be called a restructuring moratorium, a standalone restructuring moratorium. The second is restrictions on termination clauses in contracts. And the third is a sort of modified scheme of arrangement procedure, the restructuring plan procedure, Part 26A schemes as they're sometimes called. So I'll talk briefly about those three features. And first, obviously, the UK has left the European Union. It left it, I can't remember the precise date now, I think it was the end of January this year. But the Brexit completion day is, of course, the end of December. So Britain has left the European Union. Don't mention the restructuring directive. And during the parliamentary debates on the legislation, it wasn't really mentioned, though there were some oblique references stating that the UK is keeping in line with international insolvency developments. Well, sort of moving UK law closer to the market leader, Chapter 11 of the US Bankruptcy Code. And I should, Judge Michael Quinn talked about cross-class creditor cramdown. Well, we didn't have that in the UK until 2020. And Ireland, of course, have had it for 30 years, more in line with the US Chapter 11. Okay, so what about the 3 UK changes, the so-called permanent changes? Well, the first is this standalone restructuring moratorium. It doesn't need an application to the court. To get the restructuring moratorium, you file certain documents with, but and it lasts initially for 20 days, then further documents for a further 20 days, so 40 days in total. So with the agreement of creditors up to 12 months and indefinitely on court application. I should say the restructuring moratorium isn't available to all companies. There are certain companies, particularly what might be called bank type institutions, financial services companies, that are excluded. So it's a moratorium. It's a sort of, might be called a payment holiday, but certain debts still have to be met during certain obligations still have to be met during the moratorium period. And that includes financial services obligations. So in simple terms, it's a moratorium against trade creditors. It bars enforcement action by trade creditors. It means you get a payment holiday from your trade debts, but it doesn't bar financial services creditors. So effectively, you still have to pay those financial obligations during the period. And I should say it's a moratorium for existing debts. For debts incurred during the moratorium period, they still have to be paid, whether trade debts or financial service debts. Well, it's a debtor in possession type procedure. You don't need to go to court to get the benefit of the moratorium, but you do need support from an insolvency practitioner who wears the hat of monitor. That's the title used in the legislation, the name used in the legislation. And some insolvency practitioners have said, look, it's pretty difficult for the monitor because you have to first certify that the company is unlikely to be able to pay its debts at the moment. And secondly, that the benefit of the moratorium will put the company in a position that it will be able to pay its debts. So you might say those two statements that the monitor has to make are contradictory. So, or tension, they point in different directions. So some insolvency practitioners say, we won't get our hands dirty, we won't get involved in this legislation. And so far to date, even though the legislation has been in force for a few months, there have been only 2, according to the insolvency statistics, there have been only 2 moratoria. One is, the 2 quite high profile cases, one is Virgin Atlantic, and the second is the pizza company, Pizza Express. So only 2 cases to date. Okay, the second aspect of the legislation is the kind of restrictions on termination clauses in contract. This is to prevent suppliers holding business to rescue, as it were. Holding rescue to ransom is the expression sometimes used. And the third element, which I'll talk about briefly, is this new restructuring plan procedure. It's built on the existing scheme of arrangement procedure in Part 26 of the UK Companies Act. It's very similar to the Irish procedure outlined by Mr. Justice David Barniville. There's 3 differences from the existing scheme of arrangement procedure, however. One is there's no numerosity requirement, so it's not a majority in number. It's 75% in value of creditors or members, as the case may be, actually voting. And also, so that's one, so no numerosity requirement. Secondly, it doesn't, there's a financial difficulty test. So it's a special procedure for companies in financial difficulty. And thirdly, there is this facility for cross-class creditor cram-down. You need one assenting class, and the kind of tests that were suggested by Michael Quinn and David Barniville also apply in the context of the Irish legislation. Some variations, but basically the same test. So similar type issues about valuations, about fairness, they will all come into play. So what about judicial attitudes? Well, in general, well, I would say invariably, scheme applications are dealt with by specialist judges in the High Court. The two scheme Part 26A schemes, the restructuring plan procedure schemes, they've become before very specialist judges, one of whom was Mr. Justice Richard Snowden. And he provided some very valuable guidance, basically saying that the existing restructuring, the existing scheme of arrangement procedure, the case law will still be relevant in this new context. Obviously, the statutory framework is slightly different here, but bear in mind all the existing case law. So he was saying, well, in a sense, utmost good faith on the part of practitioners, all the information should be presented to the court. So the court is dealing with, as it were, a full deck, everything is in front of it. I should say, in both those cases, the Pizza Express case and the Virgin Atlantic case, all the creditor groups were in favor of the plan being approved. So the court, there was the possibility, and that's why they went for the Part 26A scheme, the restructuring plan procedure. There was the possibility at the outset some creditor groups would be against it, but in fact, they all voted in favor. They all supported the plan. So the courts didn't really have to consider in practice the application of cross-class creditor cram-down. Okay, that's more or less what I'm going to say. So the legislation is designed to be in conformity with international developments to ensure that the UK remains at the forefront. It hasn't been tested, fortunately, thus far very much in the case law, because so far, and touch wood, it won't happen, we haven't had the tsunami of actual insolvencies presented before the courts yet. Though, of course, the Chancellor in the UK, Mr. Rishi Sunak, said 2 days ago that, well, the economic emergency is yet to come. And just reading the newspapers today online, well, obviously we've had the threat with the Arcadia Group falling into an insolvency process pretty soon, one of the big retailers. Okay, so I'll leave it at that, and I'm perfectly happy to to answer any questions as best I can. Thank you very much indeed, Irene.
Thank you very much, Professor McCormick. You can mute yourself now again if you like. And now I'd like to welcome Professor Reinhard Riesendorp to talk about the new Dutch legislation, the WOA. So, Professor, if you'd like to unmute yourself and share your slides.
Yeah, thank you, Jen. I would like to put some slides on the screen. And I would like to thank the organizers for inviting me to have what I would say a challenging 10-minute talk about the WOA, the Dutch scheme, I call it, to explain that to a largely Irish English audience. But I'll try and I'll do my best. I have chosen to have two items to discuss, the key features of the Dutch scheme, because I suppose that no one or hardly anyone is known with the Dutch scheme, and I will pay some attention to the restructuring of a multinational group, because that's in the international context the most interesting point. Am I well to hear? Can you hear me? Okay, thank you. As key feature of the scheme, for the Dutch scheme, I can say it is state of the art. It will be enacted as per 1st of January, but I know that there are people lining up and companies are lining up to make their preparations. State of the art in the sense that it's a combination, a SWIFT regime combining what I would say the flexibility of the UK scheme and also the moratorium and the certainty of the US Chapter 11. Debt for equity possibilities and largely compliant with the EU restructuring directive. It starts with, as we heard before, there is what we call a light insolvency test. And the debtor must be reasonably likely that it's unable to pay its future debt, and it's forward-looking 6 to 12 months. What is the perspective? Then the debtor can initiate the restructuring process or a plan expert. And then you will ask, okay, what is a plan expert? A plan expert is someone who can be appointed by the court, discretionary, upon request of the creditors, one or more creditors, shareholders, the works council, or employees' representatives. So they have not a direct possibility to appoint, but they can ask the court to do so. Otherwise, the court involvement is really limited. If there's an uncontested situation, like Jerry said before, in the Virgin Atlantic and the Pizza Express, maybe you could have only one court involvement, and that's at the end, the confirmation of the plan. But there are the possibilities if in the interim period you need relief or that kind of thing, then you can go to court. It is like the Irish one, it's a debtor in possession proceeding. He remains in full control, even if there's a plan expert that prepares the restructuring plan. The debtor remains, keeps the management and has no consent needed from court or from the plan expert. Another important one is that sometimes there's a debate between management and the shareholder, but the shareholder cannot block the restructuring plan in itself. No, his consent is not required. Restructuring costs money. You need money for doing that, new money, and if that's brought available by parties, then they can ask the court for permission that they won't get a clawback afterwards if, unfortunately, the plan doesn't succeed. And the same applies to the set-off possibilities. Well, the plan is as flexible as one can imagine. As to the contents, you can put everything in the plan that you want. You can put a debt for equity swap, you could amend, extend, release, whatever. And you may determine who you want to include in the plan. It can be all of your creditors, but you can also say, well, I do one type of creditors, especially in financial restructuring. It can be that you pay all your trade creditors, you pay your RCF, but you have, for instance, the bondholders, you want to have a limitation on that. And only parties whose right will be affected will be put in the plan. So if you don't affect anybody's right, then that class will not be there. So the class composition is also something that you determine yourself as a debtor. If there are any, let's say, issues about it, you can go to court in an early stage to ask clarity on that. The moratorium, Jerry mentioned it in the English Plan 26A. We have the possibility under the Dutch scheme as well. It has a maximum of 4 months and it could be extended, but ultimately a maximum of 8 months. So that's a bit longer than the Irish one. We have to see whether it's needed or not. What it does is protect the debtor against creditors' claims and taking recourse. And that's an important difference with the English plan. It is also against creditors, financial creditors, note holders, bondholders can be, let's say, stayed by that. Attachments may be lifted, and if there are requests for insolvency proceedings, it can be put on hold. Now, there are interim measures possible during that moratorium, including the appointment of an observer who should take care of the interests of the joint creditors. Like England, there's a termination of owners' contracts possible. Think about leases or that kind of things. The debtor can propose an amendment of that contract. If the counterpart doesn't accept the amendment, then the debtor can terminate. And of course, the damages as a result of the termination can be taken into the plan itself. And finally, the judge, upon confirmation, will either accept that termination, approve that termination or not. Important thing is as well that ipso facto clauses and a change of control clauses are deactivated. So you can put in your documents whatever you want, but they don't have any effect. An important difference with many other schemes is the voting. It's only 2/3 needed of the value of the votes cast. So absentees don't block any restructuring by not showing up. It's only the people that appear and vote, and you need 2/3. That is the threshold. And then if there's at least one in the money class or a class in which the value breaks that approves that plan, then you can go to the court and ask for confirmation. And confirmation is, as a starting point, will be given unless there are, let's say, the international acceptable refusal grounds, that there's fraud involved or other things. The best interest of creditors test, or the absolute priority rule with some minor exceptions. Concluding on the features of the Dutch scheme, there is certainty from the start. If there's anything that you want to discuss, you can bring that to the court and have a preliminary judgment on that, or have a judgment on that. And opponents of let's say, of a plan cannot argue later if they missed that first possibility. Of course, they should be duly notified. There's bespoke interim relief possible. Whatever is needed can be done. It will be set up with a pool of approximately 12 judges from all over the Netherlands that will be specialists in this area. And if there's no appeal, if there's no contest and no protest, then it can be completed in approximately 6 weeks. And it was mentioned to let's say, the Nordic aviation case that, as like other difficult cases, will be prepared. And of course, there's a long period before this. But if you go into this process, it's 6 weeks. And there's no appeal possible. Okay, now bring shortly to the multinational group, because I think that's interesting for the people in Ireland and England. If there is a cross-border restructuring with a group of companies and there is no specific lead forum, it is difficult, and you have to rely on things, restructuring options in the various jurisdictions involved. But if there's a lead forum on the continent, and let's assume that it's in the Netherlands, then we can use 2 options in the Dutch scheme. It's what we call the EIR version, which by definition must be a public restructuring procedure, and that requires the center of main interest in the Netherlands. We also have the non-insolvency regulation version, and that can be a public one or an undisclosed one. And there you'll see that the Dutch court will accept jurisdiction if there is a nexus, and I come to that later. And this combined approach is for the multinational groups possible. How is the jurisdiction in a non-EIR version? The nexus that is required is either if there's a COMI or a branch in the Netherlands, or there are significant activities or assets in the Netherlands. The debt is governed by Dutch law, or there's a Dutch court involved. It's all like the scheme in England. If there's a significant part of the group consists of Dutch entities, and if the debtor is liable for debt of another entity over which the Dutch court has jurisdiction. And in that respect, you should note for the parent guarantees, often in large structures, they can also be striken off if there is a light insolvency test for that parent, and the Dutch court would have jurisdiction over a Dutch scheme, and you see typically that there are Dutch parents involved or Dutch finance vehicles involved for tax reasons or others. And this is my last slide. It's of course the recognition. What about this Dutch scheme? If you compare it, for instance, with the Chapter 11 that it has no formal recognition but practical effect, yes. The UK scheme nowadays, you see it that it's Chapter 15 in England, the Brussels recast, but that will stop after the legal Brexit. The Dutch scheme, in the ERR version, there will be automatic recognition throughout the EU after it's being placed on the Annex A. And the non-ERR version, recognition may be based, and that will still be discussion, Brussels 1, Lugano, domestic private international law, and I think we have now some almost 50 UCC model law variations. Finally, the other consequences, the ERR version is a public one, so it's in the registers, publicity, and the non-ERR, there's no publication, and it will be heard in chambers. Thank you, Quinn.
Thank you very much, Professor Riesendorp. We've got a few questions that have been submitted to the Q&A. I've got one here that's directed at Professor McCormick, but I think that it probably is relevant for both of the speakers. The question is, does the introduction of a cross-class cram-down amount to a further weakening of the position of secured creditors, so specifically, especially floating chargees? And this question is raised in the perspective of other European countries who are looking to implement the directive and make further advancements in restructuring. So what do you think about that? Either of you.
Jerry, it's about floating charges. We don't have that in the Netherlands.
Yeah.
Okay, sorry, I think I was muted there. I think the simple answer, I would say no, it doesn't weaken the position of floating charge holders. Maybe I should sort of elaborate on the answer, but I would say basically it doesn't, because you have to look at the alternative. If you don't, the court would look at the alternative and say, look, what happens if we don't confirm a scheme? Well, the floating charge holder would be better off by enforcing. So the scheme is supposed to leave the interested parties better off. And if you worsen the position of the floating charge holder, then they're worse off.
Okay.
The same applies to the Dutch scheme.
Okay, that's great. Thank you very much, both. I think I have one that I can direct to Reinout here from Jonathan Fuller, a local practitioner, I believe. In the Dutch scheme, there's no shareholder consent is required. Would this still be the case where part of the plan involves funds being raised by share issue? In other words, the dilution of existing shareholders?
Yeah, the idea is that if shareholders cannot block neither the, let's say, the application, the start of the restructuring, but also not the outcome. So if there's a debt for equity swap in the plan and the existing shareholder is wiped out, then because of course that person will not approve that, but then the judgment, the confirmation judgment replaces that.
Okay, great. Thank you very much. I have another one here that is a post-Brexit question, which we can't avoid. How concerned are the UK insolvency practitioners about debtors looking elsewhere, like to Dublin, to restructure their debts due to recognition concerns, so the uncertainty that's being caused with that post-Brexit, particularly now that the judiciary in Dublin has proven that it is well capable of dealing with complex restructuring, and also that there's more certainty that our processes, or that the Irish processes, will be recognized EU-wide. So Jerry, I think that one.
Well, I think there's probably some confidence that UK schemes will still be recognised post-Brexit, either under Rome 1, because the governing law will be English law. So the expectation in many cases is that UK schemes will still be recognised post-Brexit. That's one route to recognition. Another route to recognition, which at this stage is slightly more uncertain, is if the UK becomes a member of Lugano. It has applied to join Lugano, but the EU have basically parked the application and said, we're not going to deal with it till we get a trade deal, basically. I think that's oversimplifying, but that seems to be the message. But of course, we may have a trade deal. Hopefully we will have a trade deal, in which case, presumably the EU will say, okay, you can join Lugano. So that stumbling block, that roadblock to recognition will be removed. So I would say there's a fair degree of confidence that obviously it's a challenging time, that the UK scheme and restructuring procedures in general will still be seen as in a positive global light post-Brexit.
Maybe to add to that, because it's indeed like Dublin that has the advantage of also being an English speaking country, and the Dutch is not for all people, let's say, native. The easy thing is that in the Dutch courts you can use a lot of English documents. You don't have to translate everything, and there might even be the option of the Netherlands Commercial Court that is entirely English. That is a part of the Amsterdam District Court and the Amsterdam Court of Appeal. That's still a bit debated, I know, but we did the restructuring of Hema, which is a large Dutch retailer. We had to do it with the scheme in August, basically because there was no Dutch scheme yet, and it was had a Chapter 15 recognition in the US and a Dutch pledge enforcement proceedings. But that would be, most of it was in English, in all the bond documentation was all in English, and other documents. So the English language should not be a barrier to come to Amsterdam.
Good to know. We have one other question here that may or may not be fair, but I'm going to ask it anyway. It's kind of got an international flavor, so we're testing what you know about some of the other new procedures that have been introduced. We have a question about whether either of you have any views on other new schemes, particularly the Small Business Reorganization Act 2019 in the USA, or the Business Debt Hibernation Scheme in New Zealand. Any thoughts on these?
Well, that's a difficult question. I think I would I know a little bit about New Zealand rugby, but not very much, and probably even less. I have been to New Zealand, but even less about New Zealand scheme. Obviously, it's a common law jurisdiction, very similar to, in many respects, to the UK and Ireland. So, but I wouldn't say it's too far away to be popular. Maybe virtually it'll be more popular. Obviously, the US procedure, the Small Debtor Reorganization Plan, which was passed with bipartisan support, I think it's to encourage small business owners to make use of Chapter 11 type procedures. And it may be of more use to, the forthcoming reforms in Ireland, at least that are being contemplated. One of the main problems as far as the UK is concerned is, you might say these schemes are very useful to larger companies, particularly those with international businesses. The costs are too high for small and medium-sized enterprises. But there is a hope, well, maybe a hope more than an expectation, that this new restructuring plan procedure, the Part 26A schemes, may be used more widely by small and medium-sized enterprises, but it remains to be seen whether that in fact is the case.
Yeah, the same more applies to me. It's far away, New Zealand. I would love to go there, but probably COVID-19 prevents me. The Dutch scheme, whether that is feasible for the SMEs, it's part of the next part of the conference, is something to find out. I know that there are plans to sort of work with templates and have it relatively cheap, but we must keep in mind that any restructuring costs money. So if the SME is basically out of money, running out of money, it's too late. And it's the early warning idea to have it in an early phase. But I know that not all SMEs are looking forward that far to be in time and still have money for a restructuring. But the idea is to make it let's say, a consumer thing then.
That's great. Well, we're just about to the full 10 minutes for the question and answer session of this panel. So I'd like to thank you both very much for your contribution, and to all the participants for your questions. I do apologize, we didn't get to all of them, but we do have a limit on time here. So thank you. And I'll hand over to Aoife now.
Good afternoon, everybody. So I'm delighted to be moderating the SME part of today. So as many of you will be aware, the survival of viable but distressed SMEs has been a priority for the EU for quite some time. And in the last decade, the EU noted the high percentage of businesses that fit into the category of SME and acknowledged their contribution to national economies. So in the lead up to proposing a directive on preventive restructuring, and rescue, the EU also acknowledged that a lack of clarity and the differences between the approach of member states to rescue was a factor in discouraging cross-border expansion. Not only is the survival of potentially viable but troubled SMEs an aim of the EU, but it's also very clearly an aim of the two speakers taking part in this final panel. So I am delighted to be joined today by two members of the Company Law Review Group who have advocated on behalf of Irish SMEs during the recent review process. So while the content of the report submitted to the Taoiseach Department of Enterprise is currently confidential with a view to preparing heads of bill, it will of course be made in due course. But our two panelists will be able to discuss their views on specific challenges facing SMEs, in particular in the wake of COVID-19, and what changes they envisage being necessary for SME rescue to be both practical and possible. So first, I am privileged to be joined on screen by Neil MacDonald. Neil has been the CEO of the Irish SME Association for the past 4 years, and this role has seen him lobby on behalf of SMEs on a range of issues, including, of course, the topic of today's panel, the rehabilitation of SMEs. And second, then, I'm delighted to be joined by Barry Lyons, who is a solicitor specialising in corporate restructuring and insolvency. And not only is Barry a highly experienced professional in the area of rescue and insolvency, but he's also submitted a detailed proposal for the creation of an insolvency regime suited to the needs of SMEs on behalf of the Irish SME Association. So I would first like to hand over to Neil and invite him to give his presentation.
Thank you, Aoife. Good afternoon to all. I'm very grateful to be asked to speak at this event by UCC today. The topic for discussion is of great interest not only in Ireland but throughout the EU. 2020 will be memorable for all of us, not least for college students whose studies have been so radically affected by the pandemic. In February this year, ISME cautioned businesses to prepare for the arrival of a virus that hadn't yet spread beyond China. By mid-March, the government had commenced a widespread lockdown, which would have immediate consequences for business. Our chair wrote to the Taoiseach seeking the urgent provision of working capital for business, an operational plan to exit lockdown, and affordable access to a restructuring mechanism for small and medium enterprises. Irish examinership is a highly structured and a well-regarded process. It has stood the test of time since its introduction 30 years ago with the threatened collapse of Goodman Meats, but it's also expensive. Revenue estimates the average cost to be in the region of 80 to 100,000 euro. And this makes restructuring of smaller businesses an uneconomic proposition. Only a tiny proportion of Ireland's roughly 250,000 businesses could afford examinership. We expect business insolvencies in the low thousands to follow this pandemic. Yet for every 100 businesses at risk of insolvency in the UK, 10 to 15% of them can be successfully restructured, even more in the United States. In Ireland, the equivalent is 3 to 5%. And this comes at a terrible toll to employees, to business owners, and to creditors. This must change. In the second week of April, ISME made a formal submission to the then Business Minister Heather Humphreys outlining a proposal for an administrative examinership process drawn up by insolvency expert Barry Lyons. The response from the department might have been more enthusiastic, but the proposal was allowed to go forward to the Company Law Review Group for consideration. It got a good hearing at the CLRG and was assigned by the chairman, Paul Egan, to Professor Lynch Fannon in the Insolvency Committee, where significant progress has taken place over the summer. For me, it was interesting that my predecessor, Mark Fielding, had tried to get similar proposals moving in 2012 in the aftermath of the Great Recession. This went nowhere after running into stiff resistance from interested parties. However, the landscape has much changed since the last recession. Our bankruptcy laws were amended, and the Personal Insolvency Act 2012 was introduced. Creditors became more agreeable to a regime where personal or commercial insolvencies could be resolved. We were delighted at the end of April when the Banking and Payments Federation of Ireland explicitly welcomed our proposals in their plan for economic recovery. As representatives of the largest group of creditors in the country, this statement was decisive in quelling objections to our proposals. Professor Lynch Fannon co-opted the author of our proposal, Barry Lyons, onto the Insolvency Committee. And the committee was soon holding weekly nuts and bolts discussions on how to introduce speed and remove cost from small business insolvency. Much progress has been made since then, but the legislative work to come will be more difficult. It's also clear that while the practitioners involved in taking our proposals this far have been supportive, there remain some concerns at public service level that will have to be allayed before we are successful. I should stress that our proposals do not impact anyone's constitutional rights. I'm conscious that our considerations today move beyond those of small business insolvency and touch on wider areas of application of common law. In a post-Brexit world, will Ireland become the go-to EU jurisdiction for the resolution of intercompany disputes? To those that see Brexit as the sunny uplands for the Irish legal profession and our court system, I must sound a note of realism. Ireland's legal system has been subject to sustained and justified external criticism for some time. The EU Commission's 2019 Small Business Act fact sheet notes that Ireland's second chance regime, while of high performance, is deteriorating. Our time to fix insolvencies is one of the best in the EU, but the strength of our insolvency regime is rated below average. We are the fourth most expensive country in Europe in the cost of enforcing contracts. The EU Commission's semester reports have been consistent in their criticism of our legal system for a decade. The 2020 semester report states high legal costs are impacting domestic productivity and are a significant factor in SMEs failing to challenge bad public procurement decisions. Legal reforms have been long delayed with no schedule of implementation. The average length of High Court commercial proceedings has increased from 287 days in 2017 to 321 days in 2018. In enforcement of contracts, Ireland scores poorly on time required to enforce a contract in court, cost required, and quality of judicial process. The Central Bank's second motor insurance report data shows legal fees in minor injuries cases average 63% of the value of damages, even though litigated actions take almost twice as long as negotiated ones, yet only get €400 more in damages. The OECD Economic Survey in Ireland 2020 suggests that effective enforcement of our new white-collar crime laws could increase our per capita GDP by 1.6% over the next 10 years. One area of law we do attract international clients is that of defamation. US celebrities love the four courts, but the European Court of Human Rights has held our defamation laws violate the right to freedom of expression. This is normally seen as a tort against the media, but our retail and hospitality businesses are its most frequent victims. Promises to review the Defamation Act since 2017 have come to nothing. Ireland remains the only common law jurisdiction in the world without a statutory offence of perjury. ISME's campaign for a perjury statute has been ignored by the legal profession, and a High Court direction imposing a duty of candour on lawyers in asylum cases has been vigorously opposed by members of the legal profession. This stuff gets noticed by the people who matter. It is profoundly damaging to Ireland's reputation. But who benefits from the status quo? Isolde Goggin, the Competition and Consumer Protection Commissioner, in her address to the Burren Law School in 2016, asked whether the law protected incumbents to the detriment of consumers. Her forensic analysis of the passage of the Legal Services Regulatory Act is a seminal study in how incumbents stymie legal reform. The enactment of the Judicial Council Act 2019 was tortuous, and it passed into law without commencement of the Judicial Conduct Committee. The absence of this committee has already caused considerable but self-inflicted discomfort to the current members of the Supreme Court. These are all serious difficulties for a jurisdiction that sees itself as progressive and outward-looking, but they can be overcome. We must recognise that the only constant in life is change, and our legal profession must recognise that their job is to serve Irish citizens and society, not the other way around. We can make a small but significant start by promptly enacting legislation to rescue small Irish businesses. Thank you.
Thank you so much, Neil. I'd like to hand over to Barry now for his presentation. And just to let everybody know that you can put your questions in the Q&A section, and I will do my best to get to as many of them as possible after Barry's talk. Thanks.
Hello, Aoife, can you hear me? I'm sorry, I've lost sound for you, so excuse me. Thank you very much, Aoife, and thank you, Irene, for inviting me to say a few words today. So effectively, I suppose, what I want to talk about today is what I see to be issues that arise in relation to our examinership rules. As Judge Quinn said at the very outset, they have been in place now for 30 years, albeit with some change in 1999 and 2013, but very substantially, the rules have been in place they haven't fundamentally changed in that time. And from a legal practitioner's view, what I've found over the course of the past 20 years, as long as I've been working in the field of examinership, is that very frequently, in fact, I would go so far as to say most of the time, all of the features of a lawyer's job in terms of having a company go through the examinership and the restructuring process, it involves about 6 court applications, and those 6 court applications, as Judge Quinn, I think, very outset, were that initially there's a petition filed in court for court protection, which triggers straight away protection for the company against its creditors, any enforcement or sequestration against the company's assets. Then there's a confirmation of the examiner's appointment hearing. Typically, the Act provides that the court has got to, or that the examiner's got to file a report within 35 days of his of the petition or of his appointment being confirmed, and that is very unusual. So that time has to be extended to the 3rd application. In the event that the examiner isn't in a position to put proposals to the court within 70 days, but he is in a position to do it shortly thereafter, the time extended from 70 days to 100 days, then he has to file the report based on the outcome of creditors' meetings, and then the court will adjourn that pending its consideration of the issues raised arising from the exam, which is effectively a report on the entire of the process. So effectively, you've got 6 applications on behalf of lawyers, and over the course of the time that I've been practicing, I was acting for large companies. The transaction costs probably weren't quite as significant for lawyers to be involved at every one of those stages, but most, particularly for smaller companies, when you have to dial up and spend 2 or 3 days preparing for your hearing, and then you go into court and you make an application. We have an adversarial court system here, and you'd find very typically that there's nobody against you, but go through these processes and these steps, and just simply to satisfy the criteria that are set out in the Companies Act. There's no real advantage to it. The process isn't brought forward in any way. The court is ambivalent because none of the stakeholders in the process have anything to say that is contrary to the process, and therefore will typically, they'll give some insight into their views, but nothing changes from the applications that are being made. So I got to thinking, wouldn't it be great if a lot of those that otherwise have to be made were taken from the requirement to be done, and in fact that in the event the creditor had something to say to the court, that they always have the right, so that the system effectively doesn't change that significantly. That if we could say, well, why do we take the lawyers out of the process? Because ultimately, insolvency practitioners that give their opinion in respect of the company's for survival, and it's the insolvency practitioner that will put together proposals for a scheme of arrangement. It's the insolvency practitioner that will go down the road and meet the creditors, see where they're at in terms of what proposals they propose to make based on the amount of the investment that's going to come into the company relative to the company's liability, and also to compare the different creditors and how they're going to recover in any scheme of arrangement based on their priorities, the situation that they would get in the event that the company were to go into liquidation, which is the only alternative to this situation. So it was on that basis that that I literally went through the Companies Act, went through all of the different bits and pieces, and ISME with a flow chart saying this can be retained, but let's not make us owners. So this bit is very important, and I think we need to go into court with this bit. And the objective of the exercise being that we strip it all down. 30 years, there's been very significant jurisprudence on the meaning of the key points in the examinership rules. So, for example, one key element in any scheme of arrangement is that no creditor would be unfairly prejudiced in the scheme of arrangement. And the test is, would you do better in a liquidation than you're doing in the scheme of arrangement? It's a very simple test. It's a very straightforward test. As Judge Quinn said earlier on, the question of whether or not a company is insolvent has recently been determined. So these are in the case that Judge McDonald gave his recent decision on, and he's decided that the company, well, it may become insolvent in due course, but right the time of the presentation of the petition was previous to make that application on. So this kind of fine-tuning of the interpretation of the key phrases in the examinership rules has been taking place for 30 years. Practitioners know almost instinctively if the proposal being put forward an examiner is likely to fly. They know instinctively if unfair prejudice is going to arise. They're advising investors. They know how to create schemes of arrangement around process, and so that doesn't change. The key bit being that you could constantly go back into court to have the court's approval of what are typically standard steps, but most particularly at the end of the process, that the objective being that, I suppose to a certain extent, if everybody walks away from the process and they're equally unhappy, the practitioner's probably done a very good job in terms of dividing up some amount between the creditors, and the theory of it being that the principles that are applicable in examinership rules, as I say, they have been fine-tuned, that the rules are understood by insolvency practitioners, and arising, they have the ability to do an awful lot of the work that's required. And in the event, the thinking is that in the ISME proposals, that in the event that any stakeholder to the process believes that they're being unfairly prejudiced, or that they have something that a court needs to say, or if they have got, the court needs to hear that might influence the outcome, they at each step they've got the opportunity to go into court to have a judge adjudicate that particular point. In an ideal world, ISME would like to see that where opposition is vexatious, well then the creditor opposing the steps might be on risk of costs. It's probably a bit optimistic, but you know, it's the way that checks and balances and that the costs don't run out of control. So so the thinking is really to take a lot of the legals out of particularly small and medium businesses restructuring requirements. The thinking being that in our experience, the number of people, I mean, the argument, the counter argument to what we're proposing is that, for example, to be out there to game the system or to be in some way difficult in relation to taking advantage of the creditor's positions. But the reality is that happens very, very rarely. Typically, the promoters of small companies that are in difficulty are the owner directors. They are the ones counting the cracks on the ceiling at night, worrying about their companies. You might get 3 or 4% of who are out to game the system to gain a competitive advantage, etc. But it's not a feature of what I have found of examinerships. And so taking that into account, the thinking is that that move along, take a lot of the unnecessary and very costly elements to it from the system, while allowing impacted creditors to go to the court if they believe that they are being unfairly prejudiced or otherwise compromised. So I'm not sure. I haven't heard your introduction. I'm afraid I'm having a slight technical issue, and I didn't hear the start of what Neil said. So I'm a little bit on the back foot. So I'll try and see if I can remedy. Thank you.
Thanks very much, Barry. Just to check, can you hear me at the moment? I'm going to take that as a no. So we do have some. Oh, you can. Okay, great. So if Neil and Barry want to unmute their microphones, we do have some questions that have come in. So the first question is for Barry. If you can hear me, Barry. Yep. Okay. Barry, can you give an estimate of what a circuit court application would cost under your proposed streamlined process?
Because I've worked it out. Can you hear me now? Yeah. Yep. So I can, because I've worked it out. And that is about €25,000 for the admission into the process, and and this is for both the insolvency practitioner and that they might incur. It's about €25,000, and that is opposed to the petition costs currently that at probably at least €20,000 for the petition, and probably at least €60,000 for the examinership process. So that what we're proposing, we say that that's about €25,000 as opposed to at least €80,000 for the whole process beginning to end. Now that becomes compromised, because that's kind of bite-sized, and that becomes compromised to start to say that they need to make an application to court to challenge various elements of it. And I believe that each of those challenges will cost probably €7,000 is my guess. And that's on the examiner's side. So.
Okay, that's perfect. Thank you. Thank you very much, Barry. Okay, so we haven't as of yet received any more questions. If anyone does have one, please feel free to submit it. There was one question that we had in advance, which may be more, it's relevant to both speakers. But very briefly, what are the key weaknesses in government policy and existing pre-pandemic support structures for SMEs that have been highlighted by COVID-19?
Okay, Eva, I'll take that one, Eva. I suppose our initial difficulties with how things were set up would, and this would be more a business observation, that the supports being provided to government by government were very much debt-based. That's still playing out at the moment. Things like the credit guarantee scheme, various SBCI funding isn't really flavour of the month for troubled SMEs. I suppose, though, however, from a company law review group point of view, what was very interesting, and it actually took a huge amount of work by the company law review group during the summer, was the whole concept of reckless trading through the pandemic, and businesses that either sought to borrow or sought to defer repayments, businesses that were availing of bank forbearance and all that. To what extent could they be deemed to be trading recklessly? And we saw that in the UK there was considerable consideration given to that as well. And that was, you will have seen then that the Office of the Director of Corporate Enforcement came out with some guidance for company directors during the summer because of that. So hopefully that answers that question to some extent.
Thanks so much, Neil. So we haven't received any further questions, so I think I'll hand back to Professor Irene to close off today's panel.
Okay, well, thank you very much, everyone. Thank you. It's getting very near the Friday evening closing time, and as Reinhard mentioned before, virtual drinks time. So I just want to thank all of you for participating, but in particular those of you who have attended and put in questions. I would like to thank particularly our speakers and the moderators for a very interesting afternoon. There is no doubt that the coming year will be challenging for businesses post-COVID and post-Brexit. But however, the more we share perspectives, experience and knowledge, the more we will be prepared to face those challenges. And above all, our focus really is on companies and businesses as they face immense challenges in 2021. Before I close, I just want to acknowledge yet again the funding from the EU Commission DG Justice for the JCOERE Project. The website is available. You'll find more of the work we're doing in relation to corporate rescue in Europe and judicial cooperation on that website. And at the moment, the work of the CLRG subcommittee in relation to small businesses is with the department. So we would look forward to legislation next year also. I would like to also acknowledge the work of the JCOERE Consortium and our European partner universities and institutions mentioned at the beginning, and in particular INSOL Europe, which is a partner who helped us disseminate information about this event. I'd also like to thank the work, or to acknowledge the work of Molly O'Connor, our project manager, who has been so instrumental in organising the event. And we all really do act like swans, swimming gracefully, but paddling like fury underneath the water. So I would like to acknowledge again the work of the JCOERE team, but also I would like to finally acknowledge the work of the School of Law, and in particular Margaret Donnellan, who is our Advanced and Communications Manager, Pat Rice, our IT, Guy, as they are known as, and Kate Liffey-Faherty, who is the PA to the Dean's office, and the Dean himself. This event will be recorded, as was mentioned, and the recording will be available to all registrants during next week. So that's all I have to say, and thank you all extremely much for a very interesting session, and have a lovely weekend. Thank you and take care.